Well, I'll change.
Mr. Ingram, can you hear me?
Yes, I can.
Oh, okay. Thank you.
Yep.
Today was the date and time that was set for a probable cause conference. Matter is scheduled for preliminary examination January 4th at 8:30. We prepare to continue to examine at that time.
Your Honor, after a long and serious talk with the victim in this matter, the people are going to be dismissing the case at this time. She was just here on Zoom, Your Honor. I'm not sure if she still is anymore.
What's her name?
Her name is Diana Monroe.
Diana Monroe, can you please start your video?
Yes, I can. Hold on 1 second. There we go.
Okay, so the victim does not wish to proceed, is that?
Correct, Your Honor.
Okay, that's accurate, Ms. Monroe?
Yes, it is.
Okay, and so let me prepare a nollie.
The people will be getting one shortly to Your Honor.
Okay, this case will be dismissed, and that's without prejudice. So that means the people do have the right to reissue the charge against you. Okay, Mr. Ingram,
Okay.
do you have any questions at this time?
No, that was a very traumatic situation, though.
Okay, I can imagine. You need to wait 72 business hours to allow us to remove any no contact information from the law enforcement information network, okay?
Okay.
And then we'll get a copy of this nollie process for you, okay?
Okay.
Any additional matters for the record, counsel?
No, Your Honor. Thank you.
Nothing additional on behalf of Mr. Ingram, Your Honor. Thank you.
Thank you. You're all set, Mr. Ingram. Thank you, Ms. Monroe.
Take care.
Same to you. Who's it? Who's the young lady in jail post one? You know?
No.
Ma'am, what's your name?
Danielle Castillo.
Your name is Danielle Castillo.
Yes, ma'am.
Spell your last name.
Castillo. Is this district court annex?
No, it is not.
Okay, they have me in the wrong court, ma'am.
Okay, do you know what judge they were supposed to sign you into?
Yes, ma'am. Kennedy?
Okay, Judge Kennedy?
Yes, ma'am.
Okay, so you're supposed to be at the circuit court then. So you
Yes,
should let
ma'am.
the deputy know they logged you into the wrong court.
Yes, ma'am. Thank you for your time.
No problem.
Aaron's ready for Jason Moran. You want me to grab him? or something?
Yes, please.
All right.
Team speed as did he appear? He's downstairs. It's your boss, so anybody from the bonding agency appeared? I don't know if anyone from the bonding agency appeared on that one. Okay. Donald Phillips. That one's also. We're continuing, yes. I already did it. Okay. John Yang. Oh, he's here. Haven't seen him. I don't think he has an attorney. Oh, he doesn't. I'm not sure where all these people.
Yes, ma'am.
Ryan Reynolds.
Yes, ma'am.
That's Mr. Feigelson's.
Is that Miss Schroeder? She said they did a mix up and something she's representing.
Okay,
Oh,
Mr.
yeah.
Did you need to speak to Mr. Reynolds?
No, Your Honor, I thought he'd
Been dismissed. We're just leaving it on for preliminary exam.
Okay, continue to exam. That exam's gonna be January 4th, 2024 at 8 a.m. before Judge Ward.
What
You have
was the
any
date
questions?
again?
January 4th
January 4th, okay.
at 8 a.m.
That's Thursday at 8 a.m.
That's correct.
in front of Judge Ward.
Before Judge Ward.
Okay, would that be polygram or in person?
You're appearing in person.
Okay, on the 4th, 8 o'clock. Okay, thank you. Thank you, Aaron. I'll
You're
talk to you later.
Yes, I will be with you next week.
Okay.
Okay. All right, that's cool. That'll work.
Have a good one.
Okay, thank you.
Who does Antonio Triplett have an attorney?
I don't see anything in JIS.
On the record in the matter of the people of the state of Michigan versus Antonio Triplett, file number 23-03764, council appearance.
Good morning, Your Honor. Bart Buxton on behalf of the people.
Okay, Mr. Triplett, can you hear me?
Yes.
Did you request court-appointed counsel?
Yes.
I see where he requested court-appointed counsel at arraignment. Did your office do an intake for him?
Mr. Triplett, Your Honor.
Yes.
Your Honor, Adam Pfeiffer from the People. I can tell you that Mr. Triplett is currently being represented by public defenders on his other matters. So I'm guessing there's just paperwork lost in the shuffle.
What?
I remember
I see a
correctly.
couple of 21 case files are the only case files that we have in our system for Mr. Triplett, Your Honor. Is this a new case? or
This is a
one-
23 case. He was
Yes.
arraigned on the 20th.
Yeah, it does not appear in our system. So it may have gotten lost in the shuffle, so I'll have to follow up on that, but I'm only seeing a couple 21 case files in our system for Mr. Triplett, Your Honor.
And that is what I was referring to.
Okay, can I have a public defender do an intake for him? Let me see, Ms. Schroeder, are you able to do an intake with him since you're already on Zoom?
Yes, Your Honor.
Okay, I'll put him in a private meeting room with you.
Thank you.
You're in room 2. Let me add him to room 2.
I will just return to 2.
Yes, thank you.
Yep, thank you. If I can just get my cursor to work. Here we go.
I will treat his PD as PCC next week. I don't think there's anybody in post 2 anymore. I feel moved. Okay. Mr. Bruin? You're here with Mr. Prater?
Good morning, Judge. Yes, I am.
Okay, are we ready to go on the record on that?
Yes, what I'll say is I was retained yesterday at about 4:30 p.m. I'm requesting an adjournment. I think I just received the police report this morning about 8:48. I've not had the opportunity to look at it. If the court would be willing to allow me to adjourn to have the probable cause conference next, well, I will also say that I have an arraignment in 54A and a plea and sentencing in Clinton County at the same time next week. So I don't know if the court would allow me to do a little bit later or maybe appear at 9:30 or 10 and then have the preliminary examination scheduled or a separate date. I know I do have another hearing in Clinton County at 8:30 on January 11th.
On the record in the matter of the people of the state of Michigan versus Chad Prater, file number 23-03358FY, council appearance.
Thank you, Your Honor.
George and behalf of the people.
Tiffany DeBruin on behalf of Chad Prater. Both of us are appearing via Zoom and would waive in-person appearance.
Thank you. Today is the date and the time that was set for a probable cause conference. This matter is scheduled before Judge Cynthia Ward. Matter is set for preliminary examination January 4th at 8 o'clock in the morning. I did note here, Mr. Bruin, that you were recently retained and you need time obviously to get your discovery and review that with your client. And then it sounds like you also have a conflict in your schedule for next week. I don't believe that I would be comfortable with rearranging your time for next week, but if you want your client to waive the 21 days, we can just get a new date. I don't want to rearrange Judge Ward's court schedule for next week.
Yes, Your Honor, I
without her.
certainly understand.
Okay, and so Mr. Prater, you have the right to have a preliminary examination within 21 days of the date that you were arraigned. You were arraigned on December 17th, but you just, as of yesterday, retained counsel through Ms. DeBruin. And so are you willing to waive the timeline so that we can set this beyond 21 days? You're muted, sir. You need to unmute.
Judge, would the court allow me to call him?
Absolutely. It doesn't look like he. It should look like a microphone and you click unmute, sir.
Judge, I do have him on speakerphone here. I think since he answered the phone and he was using his phone as the device to utilize Zoom, he may be frozen. However, I do have him I have his voice here.
Yeah, this is me.
Turner, you hear me?
Yep. Yes.
Okay. Does your screen have a little icon that looks like a microphone?
No, but it came up with a white block that had unmute, and I hit it 3 different times, and it keeps and nothing happens.
Okay. All right. Are you willing to waive the timeline so that this matter can be reset?
I am. Yes.
Okay. Anybody threatening you or promising you anything to get you to waive the timeline today?
No.
Do you want a new PCC, Mr. Bruin, or just a new preliminary examination?
A new PCC as well, please, Judge.
New PCC, February 8th at 8:30.
February 8th at 8:30 for your new probable cause conference.
Judge, I will be out of the country. I will be here on both the 15th and the 22nd. I don't know if that works for the court.
Can you do February 16th?
Yes, Judge.
Okay, probable cause conference, February 16th
At 8,
at 8 o'clock in the morning.
and then exam February 23rd
February 23rd
at 8:30.
at 8:30 for your exam.
Yes, Judge.
Focal Court Judge Cynthia Ward. Any additional matters for the record on this file?
No,
I'll
Your
take
Honor,
the
thank
offer.
you.
I will state the offer on the record, Your Honor, because I did not know what the defense attorney was. So this morning, it is use at this time.
Offers for him to plead to a added count 2 of use of a controlled substance.
Yes, Your Honor.
Okay, any additional matters, counsel?
No, Your
No,
Honor,
thank
thank
you.
you.
Thank you. Happy New Year.
Same to you, Judge.
Anyone in Ingham County Jail Post 2? I removed him. I don't know why he brought it back. On the record, in the matter of the people of the state of Michigan versus Jason Murray. File number 23-01950 council appearance.
Kate Petrosky on behalf of the people. Karen Robinson, assistant public defender for Mr. Murray.
How are you, Mr. Murray? I'm doing well. Today was the date set for sentencing. I have a pre-sentence report and recommendation. It was prepared on December 7th, 2023. Did you get a copy of that?
No.
Talking to your attorney.
I did, Your Honor, yes.
Okay, did you go over that with your?
I did.
Okay, do you need to make corrections, updates, or deletions?
Not at this time.
Okay, you can address the court.
Yes, Your Honor, at this time, we would request that the court follow the recommendation set forth in the PSI sentencing Mr. Murray to time served. I believe at this time he has over 93 days of credit based on the PSI calculations. This was done on, I believe, December 7th. He is also serving a sentence in Clinton County.
The court will adopt the recommendation. You're sentenced to 93 days in county jail, credit for time served. Any additional matters for the record?
Nothing for the people, Your Honor. No, Your Honor.
Okay, you're all set, sir. I think there's a bond violation in here.
There is, Your Honor, but none of the subpoenaed witnesses are present.
Okay, that'll be dismissed. You're all set. Thank you.
Just question.
Got it. I don't know why they keep putting jail post 2 in here. Who's in jail post 2 taking a nap? What's your name?
Marquino,
Say it again.
Marquino,
I didn't hear you. Is Miss Donnelly here? She is. Who's on the blue M8L? What's your name, sir? Sir, can you hear me?
It's Marquino.
No, I'm talking to the person on the blue M8L. Yes, you. With the red and black plaid shirt. What's your name?
Oh, Anthony Taylor.
Just Donnelly as well. Miss Donnelly. Somebody on the court iPad? Was that who was in the jury room? The court iPad? Can you go in that jury room and grab our iPad, please? Are you, that's it? Okay, I'm gonna bring it back. From our breakout room. Ms. Donnelly.
Yes, Your Honor.
What are we doing with Mr. Taylor? We continue?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Anthony Taylor, file number 21-03078, FY, council appearance.
Petrowski on behalf of the people. Assistant Public Defender Sarah Donnelly on behalf of the defendant Anthony Taylor, who's appearing separately by video.
Okay, Mr. Taylor, your matter is scheduled for a preliminary examination in person at the court next week, January 4th at 9:30 in the morning. Your attorney has indicated to the court that we will continue to exam, so you need to appear in person next week, okay?
I understand, Your Honor.
Okay, do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Yes, Your Honor. After reviewing the police report and the footage, I'm consulting our office, we felt that it was appropriate to amend the charge from a fleeing, eluding fourth degree to a resisting and obstructing the police officer. I gave Ms. Donnelly notice yesterday, and so that's how we'll be proceeding on this case.
Stop.
Your Honor, yes, that is my understanding that the charges are being amended. I believe though, are you gonna file another complaint? Yes. I just wanted to make, for the record's sake, it's one of the court order.
Okay, I'll note that in the file. Any additional matters for today's record?
No, Your Honor, thank you. None for the defense.
Okay, you're all set for today, Mr. Taylor.
Thank you so much. So I will appear next Thursday at 9:30 in your courtroom.
That's correct.
All right, thank you so much.
You're welcome. On the record in the matter of the people of the state of Michigan versus Mark Anthony Aquino, file number 23-03744, council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Mark Aquino, who is appearing separately from the Ingham County Jail.
Okay, Mr. Aquino, today's the date that was set for a probable cause conference. One count of felon in possession, one count of assault with a dangerous weapon, that being a felonious assault, and there's 2 counts of felony firearm. This matter is scheduled in a habitual offender, 3rd offense notice. This matter is scheduled for examination January 4th at 8:30 in the morning in person at the court. Are we continuing to exam, counsel?
Yes, Your
Yes,
Honor,
Your
the people have no offer at this time, and people do need to address bond at this hearing.
You okay?
Yes, Your Honor. Just wanted to make sure.
No, give me just a moment.
Of course.
Ma'am, are you okay? Is there a place for you to sit? You can go on the first row. That back row is very crowded. And we're not gonna hold seats with laptops.
Do you want her with the front seat?
Yes, please.
You can come up here and sit.
Okay, we're gonna continue to exam, and then, Mr. Piper, you wanted to address the bond. Bond looks like it's set at 150,000 cash surety, 2,000 foot exclusion zone, victim notification if possible. It says no phone calls. You can address bond.
Yes, Your Honor. The defendant has continued to call the victim. He instructed the victim get a new phone number, which he has been calling for other inmate accounts, though he also tried to call from his own account Christmas Eve. This point, after the arraignment, it was 59 times before the arraignment. There's been at least an additional 47 after the arraignment because the defendant simply isn't stopping. I would ask that his phone privileges in their entirety be revoked, including his e-message and video visits. And I'd ask that the 2 numbers that are associated with the victim be blocked from the jail, including the new number that he instructed her to get. And for the record, I am getting the process of getting a detective assigned to this matter to investigate this more fully, determine if there needs to be witness interference charges or if the people will be proceeding at the examination under forfeiture by wrongdoing.
Okay, you're requesting his phone privileges be revoked, and what else?
That the 2 specific numbers that he has had the victim use be blocked. That way he cannot keep calling them under other inmate accounts. And I'd be happy to email those to the court as well as CC Ms. Donnelly so they're not put on the public record.
Very good. Ms. Donnelly?
Your Honor, I was provided some evidence from the prosecution in this regard. Obviously, these are just allegations. There hasn't been a formal prom violation or hearing on this matter. So I reserve a legal conclusion based on that. But at this time, Your Honor, we would just, I think Mr. Pfeiffer was also saying something about e-communications. I would just ask that he be still allowed to communicate with me through the smart jail communication system.
Oh, I'd be fine with that. I am not in the business of stopping clients from talking to their attorneys.
Okay, so I assume this matter will be set for a bond violation. So the allegation, Mr. Aquino, is that you have violated the terms of your bond conditions by making unauthorized contact with a protected party. You were advised that you could not have contact with that party at the time of your arraignment on December 20th. So only a week ago, you were advised of that. And that was that you were not to have contact directly or indirectly. The allegation is that you have made multiple phone calls after the arraignment. I note here that at the time of your arraignment, the magistrate advised you that you were not to have any phone calls then. So that appears to the court that it was already an issue. Due to the ongoing concerns of a potential witness tampering, the court is going to grant the prosecutor's request. I'm going to revoke your phone privileges entirely. I'm also going to revoke your e-messaging. You're only allowed to have e-communication to your attorney. Do you have any questions?
Yeah, I have a question.
What's your question?
How can I call the victim 49 times while I'm locked in my cell 16 hours a day? It don't make no sense.
You should probably have your attorney and the prosecutor talk about that information. I don't have any evidence before me. I can't answer that question. Do you have any questions for the court, though?
Yeah, I feel like I'm getting railroaded.
Okay, that doesn't sound like a question. Any additional matters for the record?
Not from the people, Your Honor. I'd only note that I just emailed all the parties with the phone numbers to be blocked.
Nothing for defense.
Thank you. You're all set, Mr. Aquino.
Thank you, Your Honor.
Let's see, Mr. Triplett, we're gonna continue your matter till next week. We'll treat it as another probable cause conference, okay? That'll give the public defender office time to work through your application. How did I just lose my pen? Did I put my pen in that file? Is my pen in that file?
Oh.
Did you hear me, Mr. Triplett?
Yes.
Okay, you can let the deputy know that you're all set. This is Mr. Speed.
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Hakeem Ahmad Speed. File numbers 23-03301, 23-03228. Council appearance, please.
Good morning, Your Honor. Bart Buxton on behalf of the people of the state of Michigan.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Speed. He's standing present to my right.
Okay, Mr. Speed, file number 23-03301 was set for bond show cause as well as a probable cause conference. I believe it probably was set for bond show cause because I revoked the bond to issue a bench warrant. It looks like I did quash the warrant on the 9th. And I don't think anyone has appeared today from the agency, so we'll cancel the show cause. This matter is scheduled for actually, I don't think we have an exam date because it's not in my file. He said it's a probable cause conference in this matter and that the offer was for him to participate in the drug court. Being screened for that.
Your Honor, he was set to be assessed by that. I spoke with the person of contact at the end of last week at the 54B court that does that. Couple of updates on that. She said due to some type of mix-up, Mr. Speed was not properly assessed for that, but she also told me that even if that had occurred, they are currently at capacity and there would not be space available for him in the program, even if he was assessed and deemed eligible for that. So there is no currently date set for preliminary examination. So I would ask the court, Your Honor, to set preliminary examination dates in both of these matters. And in that interim, if there is availability that comes open in the specialty treatment court for Mr. Speed to participate in by that time, that is something he would be considering. I've also made an offer or a counter offer on Mr. Speed's behalf to the people that they are going to consider. So I think we're going to have a plan B in place in case that does not work out.
Okay, so we'll go ahead and set this matter for preliminary examination. Actually, both files need to be set for preliminary examination. February 15th. February 15th at 9 a.m. on both files.
Thank you, Your Honor.
No problem. Any additional matters to be addressed today?
Nothing from the people, Your Honor.
Nothing additional on behalf of Mr. Speed, Your Honor. Thank you.
Thank you. You're all set for today, Mr. Speed. I'm not seeing John Yang. Anyone here for John Yang? I'll benchmark him. Jill? What's your name? Can you say it louder, please?
Mercer.
I didn't catch his name. Did you get it? Mercer, Mr. Mercer. That's Mr. Freeman. Who's in jail post 2? Visit 3. Sir, what's your name?
Collins.
Alan Collins, Mr. Goodrich. He's on, he's talking. Okay, Mr. Collins, did you speak to your attorney?
Yes, I've already spoken to him.
Okay, he said you're continuing to exam, so you're all set, okay?
All right, thank you.
You're welcome. Mr. Freeman?
Good morning, Your Honor.
Okay. On the record in the matter of the people of the state of Michigan versus Wyvon Verser, file number 23-03387, council appearance.
Petrosky on behalf of the people.
Stephen A. Freeman, Your Honor, public defender on behalf of Mr. Verser, who appears via Zoom.
Okay, Mr. Verser, today was the date in the, today was the date reset for a probable cause conference. Mr. Freeman, we didn't see you last court date. We didn't get any information that you were not going to be here.
I recall one of the other public defenders appearing in my place. I think it was
No one appeared. We had to figure out what happened, and then we found somebody, and then we were told you were possibly in trial. No one specifically indicated where you were.
Yes, Judge, I did have a week-long trial. Judge Dragon's courtroom.
Okay, I don't know that anyone properly communicated that to your client. And so, have you spoken to him since then? Have you spoken to him since then?
I can't hear you, Judge.
Have you spoken to him since then?
Yes, I have.
Okay, how do you want to proceed on this?
Your Honor, for the record, the people have offered a resolution to the matter that would consist of my client pleading guilty to possession of controlled substance as well as 1 count of felony firearm. I've discussed this with Mr. Verser, and he is in agreement with me that that is of sufficient consideration to waive preliminary examination, and that is what his intent would be this morning. Thank you.
Okay.
And the people would also be waiving the preliminary examination and ask the court to bind over to the court.
Okay, thank you. Mr. Verser, that's what you want to do? You want to waive your preliminary examination? Okay, you understand that you have the right to the preliminary examination?
Yes.
You understand the purpose of the exam?
Yes.
Okay, so you want to waive your right to require the prosecutor to put forth evidence to establish that they have probable cause that a crime was committed and then probable cause that you committed the crime, correct? Excuse me?
Yes.
Okay. Anybody threatening you to get you to waive your examination?
No.
Has there been any promises made to you in exchange for a waiver? bind over date's gonna be January 10th. That's the date the circuit court will get the file from this court. You don't need to appear in court on that date, okay? The next court date will be in circuit court. It'll be for a pretrial. Your attorney will be made aware of that date, okay? A bond in this matter is not in the file. What's that?
He's got parole hold, Your Honor.
I recognize it. He does have a 10,000 cash surety bond in here. That will continue on this file. That way he'll be accruing time. Any additional matters for the record?
Nothing from the people, thank you.
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Versa. Justin Caswell. Justin Caswell present.
I'll double check all the way to this.
My case judge, I haven't yet seen him.
Okay. Okay, we'll fix more. Mr. Caswell. Kyla Marshall present.
She is, Judge.
Okay, on the record in the matter of the people of the state of Michigan versus Kyla Latrice Marshall, file number 23-03490, council appearance.
Good morning, Your Honor. Bart Buxton on behalf of the people of the state of Michigan.
Karen Robinson, Assistant Public Defender for Ms. Marshall.
Okay, and we reset this matter for an examination. I'm sorry, this is scheduled for a probable cause conference. We were here back on the 7th. And it looks like I found good cause to adjourn. And there was some concerns expressed by the defendant that Mr. Doyle had been hired by the alleged victim in this matter. I think I requested some information to be provided, but I don't know that that's been provided. Is Mr. Doyle here? I saw him. I don't see him now. Let's see. Ma'am, you rose your hand. You might want to run whatever you want to say by your attorney. Okay. So let's see if we can track down Mr. Doyle. He may be in another courtroom. I did see him speak in here earlier. And if that is the case, and he has the paperwork or whatever it is he needs to provide, he can provide it to the prosecutor to review. We're off the record until we find Mr. Doyle. On the record in the matter of the people of the state of Michigan versus Brandon Craybill, file number 23-03160, council appearance.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Okay, and I see Mr. Craybill is present via Zoom. He was without counsel. My understanding from my last notice, we were still waiting for the bond to be applied on this file and waiting for some paperwork to catch up. Do you know if that's taken place?
I checked your first thing this morning, Your Honor, and the bond has not yet been applied.
I'm not sure what the holdup could be other than processing during the holiday. I don't know what other issues could be tying up the bond. And as we continue to put this out, I'm sure there's still amounts that are accruing. Is that correct?
Yes, Your Honor, but the defendant actually made his December payment as of yesterday. We received a receipt for that. So, it is accruing, however, he is paying it.
Okay, very good. Okay, I don't know if you can get a hold of someone over at the front of the court or find out what's going on at the circuit court as to why that there is such a delay. We've set this matter out multiple times to allow that paperwork to catch up. I'm gonna set it out again and hopefully we'll have a resolution by then.
Yes, Your Honor. We assume the same thing you do. It's probably the holiday. But we will check, Your Honor.
Thank you.
January 11th at 9.
January 11th at 9 a.m.
Thank you, Your Honor.
Mr. Craigville, do you have any questions today for the court? You're muted, sir.
Yeah, sorry, I was having some issues with my screen. Yeah, that works for me. Sorry.
No problem. Okay. Okay, without any other questions, you're all set for today. Thank you, counsel.
Thank you, Your Honor. Happy New Year.
Same to you.
Thank you.
No problem. On the record in the matter of the people of the state of Michigan versus Lavelle Gray, file number is 23-00274. Council appearance.
Chief Petrowski on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Gray, who is present. I don't think he has a screen on at the moment. Mr. Gray, can you turn your screen on?
I am not sure if he is away from his computer or if he is aware of as to how to start his video. It was on earlier, but I do notice that it's not on now. He also was not responding to the court's request to unmute his device. Do you have his phone number?
Yes, I do have his number.
Okay, I'll go off the record so you can give him a call.
All right, thank you.
Well, first off, you're right.
Okay, back on the record in the matter of the people of the state of Michigan versus Lavelle Gray. Today was the date and the time that was set for a competency review. I do have an updated competency report. It was dated for December 14th. Did you get a copy of that, counsel?
Yes, Your Honor, I did, defense did receive a copy of it. I have not been able to necessarily review it with Mr. Gray, but I don't necessarily think that that is essential for the moment, mainly because I was out with COVID, so I have not been able to talk to him about it.
Okay, did the prosecutor get a copy of the report?
Yes, we received it.
Okay, the report opinion is that Mr. Gray remains incompetent to stand trial. Counsel, do you have any reason to object to the findings or the body of the report?
No objection to findings to your point.
No objection, Your Honor.
Okay, the opinion is that Mr. Gray could potentially be restored to competency within the statutory time frame if he was provided a structured inpatient hospital setting. The court's going to adopt the body and the conclusion of the report without objection and incorporate that as part of the court record. And it will be ordered to undergo a course of structured treatment in an inpatient setting. There is a very long waiting list for that purpose. So I recognize the court says they believe that he could be restored within the statutory timeframe, but we actually need a bed to become available. And I have other cases much older than this that's been waiting for space to be available for this purpose. So we'll set this out. We'll follow up internally for review to see if there has been a bed made available. And we will set this for periodic review before the court. Let me get you a review date now. Give me 60 days. February 29th at 9. February 29th at 9 a.m. will be our next review date.
I didn't hear the date, ma'am. Can you say it again, please, for me?
Yeah, February 29th.
Okay, yes, ma'am.
What time you're on?
Okay. Any additional matters for today's record, counsel?
Nothing for the people. Thank you.
What was that time, Your Honor, on the 29th?
9 a.m.
9 a.m. Very good. I have that here, and Lavelle, I will be in touch with you soon once I'm able to get back in the office. Thank you.
Okay, I appreciate you guys so much.
Yep.
Have a good one, sir.
Yes, ma'am. You too. Happy holidays.
Same to you.
Same to you. Thank you, Your Honor.
Thank you. Ms. Councilman, which matter are you here for?
I'm here for the Johnny Sock case.
As am I, Your Honor, as well. Still.
This Mr. Sock?
He's right there.
Did he get his fingerprints?
That's their jail.
Oh, there's Blue Beach jail.
Yeah.
Oh, he's not in jail anymore.
Yeah.
Okay. On the record, in the matter of the people of the state of Michigan versus Johnny Sock, file number 23-03700 and 23-03699. Council appearances.
Sage Castleman on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Sock. Mr. Sock appears in the courtroom live today, myself in remotely due to health.
Mr. Sock? How are you? Today's the date and the time that was set for a probable cause conference before Judge Cynthia Ward. Both these files are scheduled. Ma'am, what's your name?
I'm his home manager. It's Shaktian McAdoo.
Okay. You're his home manager?
Yes, he's in the AFC home.
Okay, but does he have issue understanding what's going on here?
If sometimes he does get asked for.
Okay, he does have an attorney. You can have a seat there, and if we feel the need for you to come forward, we'll do that at that time, okay?
Thank you.
Okay.
Let's see here.
No, I was telling her she doesn't have to stand, but you're gonna stand, okay? Do you understand what's going on so far? Okay, so today was set for a probable cause conference before Judge Ward. I am not Judge Ward. She's not in today, so I'm covering this for her. Your matter is scheduled for preliminary examination before Judge Ward next week, January 4th at 8:30 for both matters. Are we continuing to exam, counsel?
Your Honor, at this time, the defense, based on previous knowledge of the client as well as his current status with the AFC home, is going to be making motion for a competency evaluation as to both files, which would involve, I think, a waiver of the timeline and by virtue of that.
Okay, and Ms. Castleman, there's no objection to that, is there?
No, that is understandable. We are willing to waive the timelines.
Okay, due to the motion for competency evaluation, the court's gonna find good cause to go beyond the 21-day timeline. So for your information, Mr. Sock, you do have the right to have a preliminary examination within 21 days of the date that you're being arraigned. Your attorney believes that based on your condition, you need to have an evaluation as to your competency to stand for trial, okay? Do you have any questions so far? Okay, so we'll get this matter set out for a review date. And then Ms. Schroeder, did you prepare paperwork or are you going to get that paperwork prepared and before Judge Ward?
I am going to have that paperwork ready today. Is it all right if I submit it to Your Honor or Ms. Nash?
You can send it to the court and the court will file it or will review it. Let's see here. Okay. You give me a review date on this for Judge Ward's file.
The clerk.
Okay. You'll get a review date from the clerk's office. You can submit your paperwork or send it over to Ms. Nash when you get a chance.
All right, thank you, Your Honor.
Any additional matters for today's record?
No, Your Honor, thank you.
No, Your Honor, thank you.
Okay, you're all set. Thank you. John Greathouse, present.
I believe, and I apologize, I don't remember which attorney I emailed with, but I had emailed with his attorney and we were not going, it was going to leave the PC set for prelim.
It's not in.
We don't have an attorney.
But it's Ficklin, is that? who it
Oh,
was?
yeah, it's Ficklin, yeah.
Okay.
My apologies.
Continue to exam.
Yeah.
Yeah, that's one.
Alex Harris, present. That's Mr. Goodrich. You don't have a report.
No, I highlighted it.
Oh, this is for review. We can reset it.
What did she say for that one? I just need to know when to set it. Some of the other facts highlighted.
This right here. December 20th. It said that he has their first available appointment is going to be the 17th at 9.
So that one hasn't been seen yet.
Yeah, the highlighted part is just said that they saw him on the 20th. The
So
report
that
is not completed, and Mary Harris has not been scheduled yet. Our first appointment. This one's talking about more than one case.
Yes.
Yeah, so no, there's just no report yet.
Okay.
Yeah.
A review February 2nd at 9.
We'll set it for review February 2nd at 9 a.m. Okay, back on the record in the matter of the people of the state of Michigan versus Kyla Marshall. Okay. Council appearances.
Good morning again, Your Honor. Burt Buxton on behalf of the people of the state of Michigan.
Karen Robinson, Assistant Public Defender for Ms. Marshall.
Okay, and then I do have Mr. Doyle. Can I have your appearance, please?
Yes, Dan Doyle, appearing on this record now.
Okay, and so this matter was reset at our last court date back on December 7th. Ms. Marshall, that is, expressed some concerns about who had retained Mr. Doyle for her representation. Mr. Doyle was supposed to provide some paperwork to demonstrate that he was not retained by the victim in this matter.
Oh, yeah, and I didn't understand as far as providing paperwork, but I did research my call log to understand the information on my initial contact.
I'm sorry, can you speak a little louder because there's some stuff going on?
Okay, and I do have my information regarding my initial contact regarding Ms. Marshall and what happened afterwards.
Okay, your initial contact was with the victim or no?
No, not with the victim. I got a call from a relative who indicated that it was Ms. Marshall's uncle or she aunt or something to that nature. Gave me a phone number. I then reached out to her. Know anything about the case. Somewhere down the line, I got the discovery. I knew that somewhere down the line, I confirmed that it was a conflict. I advised Ms. Marshall that there was a conflict. Despite knowing that there was a conflict, she wrote me indicating that she did not want to quit on the case, and
she wanted to waive the conflict, is what you're saying?
Essentially, yes.
Okay, but your payment, you didn't get payment from the victim?
Oh, no, absolutely not.
Okay, ma'am.
I do have documentation from the plaintiff in regards to his messages.
The victim? The plaintiff, the victim in this matter, you mean?
Yes,
Okay.
yes. In regards to him saying that he purchased the lawyer, as well as what I was saying previously about the days he had purchased and him asking to pay his rent and things like that.
Okay, is that evidence been provided to the prosecutor's office?
It has not, but we do have copies too.
Okay, well, I'll instruct your attorney to provide that to the prosecutor's office, okay? Okay, as far as Mr. Doyle has presented to the court, I don't have any reason to believe that he was aware when he took this case that he was, that there would have been any potential involvement or conflict. It sounds like he did notify you that when there was a conflict. And what you're stating to me does sound more like an issue involving the alleged victim, and I don't know that to be the case, because I don't have the evidence. Ma'am, you wanted to add something?
Yeah, so Darius contacted him, then the lawyer contacted me.
How do you know Darius contacted him?
Because the lawyer told me. the lawyer let me know that Darius retained him. So, once again, when I was stating in regards to Darius's, his child's mother reaching out to me and asking me questions, Darius got upset and then called my mom, which I have her here with me today, in regards to him saying, he was coming to court, this, that, or the other, and it's a problem. I'm making problems between him and his child's mother. So then I contacted Mr. Doyle, and I told Mr. Doyle what happened, and he said, I'm gonna reach out to Darius to find out if he's gonna come to court or not.
Okay, so your statement is that Mr. Doyle told you that Darius retained him?
Yes, Mr. Doyle has been, I don't know how to do the mediator. He's been speaking between both of the plaintiff and the defendant.
Okay, yes, sir.
First and foremost, that's not true regarding me being retained by the victim in this matter. That's not the case. I just want to indicate that for the record.
Okay, you've already indicated that. So what I am going to do is I'm going to allow her attorney to provide any information that she believes that she has to support her concern about any potential conflicts or tampering to be provided to the prosecutor's office. They'll flush it out and they'll provide, or they'll notice the court if I need to set this for a hearing regarding that issue. Okay.
Yes, Your Honor.
Okay. At this point, I'm not going to set it for a hearing because I don't have that information. I don't think it's appropriate that you give it directly to me. It should go to the prosecutor's office and they can look into it and investigate further. They'll notify the court if we need to address that. At this point, we need to proceed with an examination. Is that correct?
But yes, that's the next step.
Okay, so let me set this for an exam date because I don't believe I did.
We can do February 16th at 9:30.
February 16th at 9:30. Any additional matters for today's record?
None from the people, Your Honor. Thank you.
No, Your Honor, thank you.
Okay, we'll get you a notice to appear, okay, ma'am? And then we can provide those documents to the prosecutor today.
Yep.
Right now.
I believe so. Yeah. No, that was the one I thought you said that was that he was hired by.
Oh, that was
Fickling.
Okay.
Yeah.
I just don't have his
Appearance. We need to get his appearance. Alex Harris. We took care of that one, correct? Okay, I saw Mr. Milks peeking, but I don't know what happened. Ms. Wangi, you're here with Mary Harris.
I'm here with stuff.
What about Mary Harris? So my docket for forensic review. Oh, that's the one that we need to reset.
the highlighted portion is about her.
They're gonna have an appointment on the 17th. Well, it'll be the 17th, then they'll have to give us a report, so. Yeah, definitely March.
March 7th.
at 9. March 7th at 9 on Harris. And then it's still for presence? Okay, on the record in the matter,
Before we do Todd, can we do Teresa? And why that is,
well, that was the first on my,
okay,
yeah, it comes before, yeah, no worries. On the record in the matter of the people of the state of Michigan versus Teresa Lynn Stouffer, number 23-03528, council appearance.
morning, Honor, George, and on behalf of the people.
Good morning, Your Honor. Ashley Plessis on behalf of Ms. Stauffer, appearing by Zoom, but Ms. Stauffer is in the courtroom.
Ms. Stauffer? Okay, you can come up to the table. Today was the date and the time that was set for a probable cause conference before Judge Cynthia Ward. This matter is scheduled for a preliminary examination before Judge Ward, January 4th, 2024 at 8 o'clock in the morning. I'll be continuing to exam.
No, Your Honor, there's been a plea reached in this matter.
Okay, then we'll be setting for a plea before Judge Ward.
Okay.
You may want to just take that January 4th date for a plea. Is that correct?
Yes, please.
Okay, we'll have that converted to a plea. That way you won't have to have any witnesses subpoenaed. You want to put the offer on the record?
Yes, Your Honor, it would be abandoning, well, Your Honor, actually I won't, just because part of this plea is contingent on the other plea, so. With the co-defendant in this case.
Part of the plea is contingent?
Yeah, so if, depending on what the outcome is with this, is the outcome with that, if one doesn't happen, the other can't happen.
Okay, but did you communicate the offer to her?
To the defense attorney, yes.
Oh,
He did, Your Honor, yes, that's correct.
Okay, sounds good. All right, I'll note that in the file. We'll set it for plea. It's set for plea January 4th at 8 a.m. before Judge Ward.
Thank you. And Ms. Stauffer, you have to be there at the same time, same place next week. So I know you don't have a phone and I'll be there as well.
Do you have any questions, Ms. Stauffer? No. Any additional matters for the record today on this file?
None, Your Honor, thank you.
No, Your Honor.
You're all set, ma'am.
Good morning.
Happy holidays, everyone.
Same to you. On the record in the matter of the people of the state of Michigan versus Todd Stauffer, file number is 23-03527, council appearance.
Good morning, Your Honor, George, and on behalf of the people.
Good morning, Your Honor. Very everyone, you from Mr. Stauffer.
You're Mr. Stauffer?
Yes.
Okay, today's the date and the time that was set for a probable cause conference. You're scheduled for preliminary examination before Judge Cynthia Ward, January 4th, 2024 at 8 o'clock in the morning. How are we proceeding on this?
Now I'll defer to the defense at this time.
We're just going to leave it for preliminary exam.
Okay, I'll note here, continue to exam again. That's at 8 o'clock in the morning next week, January 4th, before Judge Ward, okay? Do you have any questions, Mr. Stauffer?
No.
Any additional matters for the record?
None, Your Honor, thank you.
You're all set, thank you. I saw Mr. Milks, did he leave?
You made me another call, Your Honor.
He just peeked in there.
Yeah, I think he's actually speaking with Mr. Buxton.
Okay, sounds good. Sounds good. Mr. Scheck, which matter are you here for? Oh, I see. You're here on McLaren versus Tiandra Gill. Is
That's
Tiandra
correct,
Gill
Your Honor.
present? I've not seen Tiandra Gill. Have you been in contact at all with her?
Other than I received a letter, Judge, dated November the 28th of 2023, from her employer indicating that her request for extending her FMLA leave has been granted through March the 1st of 2024. So I guess in order to make it expedient, I would ask the court to set this matter for June of 2024, so that Ms. Gill would have a month and a half to be able to uh, garner some savings after she goes back to work. And at that time, it may be more prudent to turn this into a motion for an installment payment.
Okay. June 17th at 2.
June, will we receive a notice, Judge?
You will.
Okay, once again, ma'am,
June 17th at 2 p.m.
17th at 2. Thank you very much, Your Honor. We appreciate your time today. Have a
Thank
happy
you.
new
Have a
year.
good one. Same to you, sir. Mr. Sparks, you're here on behalf of Lake Michigan Credit Union.
Yes, that's correct, Your Honor.
Okay, and I see a Carrie Ray Hunt. This is a discovery matter. So I'm going to swear her in and then place her in a private meeting room with you.
Okay, thank you. We don't remember, I'm sorry.
Ms. Hunt, please raise your right hand. Please raise your right hand.
Okay.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, I am.
Okay, and counsel, you were going to say something?
Yes, we don't remember, and I don't show that we filed a request for discovery, but we do still have the file in our office. But we did just switch computer systems, so I don't know if it was something was filed by mistake or not, but.
I'm not following what you're saying. This was a matter that's clearly been ongoing. It's for discovery. It's a creditor's exam.
Okay, we'll proceed with the creditor's exam. Thank you, Your Honor.
Okay.
And are we free to leave once we're done in the breakout room?
Yes, unless you need a control date, you're free to leave.
Thank you, Your Honor.
Thank you. On the record, in the matter of the people of the state of Michigan versus Barbara Bruner, file number 22-01103, FY council appearance.
Georgia, on behalf of the people.
Okay, are you Ms. Bruner?
Yes.
Did she have a turn?
She was initially denied, Your Honor. I was informed that she's gonna reapply today. We believe it's set as a preliminary examination. With no witnesses being required to come, we can figure out addressing the issues at that time.
Okay, you're gonna reapply for public defense counsel, ma'am? Did you speak to a public defender already today?
Well, the one that did my grade, yes.
Okay, but not today, you didn't, okay. I'll note here for Judge Ward purposes that you'll treat next week as another probable cause conference, and then she can address the timeline then as to when you have your preliminary examination, because you do have the right to have it within 21 days of your arraignment, okay? Do you have any questions today? Any additional matters for the record today?
Not for the people, Your Honor. Thank you.
You're all set, ma'am. Ms. Donnelly, are you representing Mr. Smith?
Yes, Your Honor.
On the record, in the matter of the people of the state of Michigan versus Marion Antonio Smith, file number is 23-03734, council appearance.
Georgia, on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Marion Smith is appearing separately by video.
Okay, Mr. Smith, today's the date, time that's set for probable cause conference. You do have a preliminary examination before Judge Ward next week, January 4th at 8 a.m. Are you continuing to exam?
Yes, Your Honor.
Sure.
Okay, so you'll appear in person next week before Judge Ward, okay, Mr. Smith?
Okay.
Do you have any questions?
No.
Any additional matters for the record, counsel?
Yeah, thank you.
No, Your Honor.
You're all set, sir. Thank you.
Okay, thank you.
No problem. What's your name in the jail? What is your name in the jail?
Matt Bauer, B-A-U-R.
Okay, I'm gonna put you in the room with your attorney.
Okay.
Mr. Meltz,
Yes, Your Honor.
you have Carrie Curtis with you today.
Yes, ma'am.
On the record, in the matter of the people of the state of Michigan versus Carrie Gerard Curtis, file number 23-03378, council appearance.
Good morning, Your Honor. Burt Buxton on behalf of the people of the state of Michigan.
And good morning, Your Honor. Stephen Mills on behalf of Mr. Curtis. Mr. Curtis is present and staying to my right at this time.
Okay, how are you, Mr. Curtis? Okay, I'm sorry. I couldn't hear you. I said, how are you?
I said, fine, how are you?
I'm well, thank you. Today was the date that we reset this matter for preliminary examination. I believe this was reset because the defendant was looking for a potential witness. Are you ready to proceed at this time?
Your Honor, the people were ready to proceed, Your Honor, until talking to defense. It sounds as if there was this potential witness today. This is the first time that there was any mention to our office of this potential witness. We now have a name and a contact information. At this point, Your Honor, due to what the witness has stated, we believe would be in the best interest to adjourn this matter for the officer to take statements from the witness at this time prior to the exam, Your Honor.
I've already waived the timeline at the last court date, so we'll get you a new date.
February 23rd at 8:30.
February 23rd at 8:30.
Thank you, Your Honor.
No problem. Do you have any questions for the court today, Mr. Curtis? Any additional matters for the record today, council?
None for the board.
Sorry, Your Honor, everything that, Swanson indicated was absolutely correct, Your Honor. We do have this witness. He just came in today. He was just made, his name, phone number, contact information was just made aware of me this morning today. I know this is a surprise to the prosecutor's office as well. Due to the nature of the situation here, it may be one where I have to withdraw from the case, just to give the court a heads up, that I may have inadvertently become a witness in this matter as well. As to the statement of the individual who was here this morning, either way, that is something from my office. My office will take care of, and obviously we'll update the court, update the prosecutor's office as necessary in this matter, Your Honor. I just wanted to give the courts a heads up with that. And otherwise, though, Your Honor, nothing additional at this time. We
You
appreciate
believe you may become a potential witness to the count one controlled substance?
potential witness to the statement of the individual, statement of this witness, Your Honor, who's come here today. Just as an offer of proof, Your Honor, we believe is going to be indicating that the controlled substances belong to him. It's indicating that he had it in this vehicle, in this case, essentially saying that my client did not have any knowledge of this, Your Honor.
So you spoke to the witness.
Yes, Your Honor.
This is typical for attorneys to speak to witnesses in preparation for their client's defense, and now you believe you're gonna be a witness.
If the witness were to go up on the stand and plead the fifth, it could create a situation, Your Honor, where it's a statement against penal interest. Due to pleading the fifth, it could be something where the individual then would be an unavailable witness, Your Honor, thereby invoking the potential necessity for another individual to testify to what the individual said, Your Honor. It's still
Sound like it would be a issue for the circuit court and not for this court.
Which is why we're trying to get the statement through an officer, Your Honor, to try and negate.
Sounds exciting for the circuit court.
Always appreciate, Your Honor, and thank you. I just want to get forward that up.
No worries. Let's go ahead and get you a new date on this. February 23rd at 8:30.
That's the same.
Same day, it's the same date. Okay, and then I noted your concerns in the file. Any additional matters for the record today?
No, Your Honor.
Nothing for the defense. Thank you very much, Your Honor.
Thank you. You're all set.
Do you have a happy New Year, Judge?
Same to you. Have you seen DeAndre Williams? He said it was after that was Judge Ward's case.
That was, here, and that was.
Continue.
I just need to double check.
He said that, Ms. Wong, he said that there's.
Oh, okay.
What about Charles Wright?
Charles Wright, let me yell him. All right.
Ms. Donnelly, you have Darion Summer with you?
I do, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Darion Summer, file number 23-02789, counsel appearance.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Darion Summerhour, who is present and standing to my right.
Okay, how are you, Mr. Summerhour?
Fine, how about you, Your Honor?
I'm doing well, thank you. Okay, today was a date that was set for preliminary examination. I remember back in September, it looks like there was a offer as to a global resolution. Our record indicates that the defendant did not want to move forward with a plea and wanted to proceed with this exam. Is that still the case?
It is, Your Honor. I wasn't present for the preliminary exam that was the first preliminary exam that was scheduled for September 28th, and I'm still confused about what happened at that proceeding. I don't know which witnesses appeared. So when it was set for the last court date, it was set for a plea, and that plea did not go through. So yes, I'm still expecting to have witnesses present for a preliminary exam.
How many people have a witness present to run the exam today? So also the global offer is still open.
Okay, will that offer remain open at the time of the exam, or is it?
No, if defendant decides to proceed to exam.
Are we ready to call our witnesses?
I don't, which witnesses do you have?
I have Officer Ryan Brooks.
Okay. All right. Your Honor, if I may be allowed to speak with my client off the record for a moment.
Please do.
All right, the record.
On the record, in the matter of the people of the state of Michigan versus Matthew Bauer, file number 23-03115 FY, council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, on behalf of Matt Bauer, who's present by way of video conferencing from the Wayne County Jail this morning, Your Honor.
Okay, Mr. Bauer, can you hear us?
Yes, ma'am.
Okay, today's the date set for a preliminary examination. The defendant is not present in the courtroom due to health concern at the jail. Mr. Feigelson, you were going to speak with him privately to see how we're going to proceed for today. How are we proceeding?
Yes, Your Honor, I've had a chance to speak to Mr. Bauer. Mr. Bauer wishes to exercise his right to be here in person for a preliminary exam, so we'll be asking the court to adjourn the exam tonight, so he can be present.
Okay, Madam Prosecutor.
Your Honor, we understand the defendant's right to be here. However, we did in this extenuating circumstance ask if he would consider waiving this, as we have two minor children and their mother that drove all the way from Missouri to be here for this examination and are prepared to proceed today. However, I do understand the court must follow the law, and if he is unwilling to waive his right, it is what it is.
Okay. Yeah, he does have the right under the Constitution to confront his accusers in court. And as the law stands right now, that does not include a virtual appearance unless he's waiving that appearance. And that's even an appearance of the alleged victims appearing via a virtual mechanism in the future. So with that being said, the only choice that I have is to reset this for a new date and time. And I don't know if we're able to talk to your victims to see if there was a time that would work for them.
Your Honor, yes, I was. They are going to be able to make it work at the court schedule. We would just ask for at least 3 to 4 weeks so that they can get some more funds saved up. It's quite an expensive trip.
Okay, so at least 30 days.
That would be my request, Your Honor.
Probably even more than that, but February 23rd work?
For the people, yes.
February 23rd at 9:30.
That works for the defense as well, Your Honor.
I would suggest that due to the nature of the travel involved in this matter, that the parties probably want to do some level of consultation, maybe 3 days prior to make sure we don't have any health issues or other issues.
I was actually going to ask for a couple of orders from the court, Your Honor, that I could prepare and for signing, I'd be asking that the court order the jail to do COVID testing on him 48 hours prior to a preliminary examination, so that we could avoid this problem in the future. And for a separate reason that I can address if we're going to talk about bond, I have another request for your honor as well.
Judge, I think the first request is appropriate, Your Honor. There was a plea offer extended to Mr. Bauer. If that wishes, if you wish to accept that offer, we'll let Ms. Smith in the court know, and we can always deal with that accordingly in that conversation.
Okay. I will place, or I will grant your order, and you can put that in writing, to require the jail to test at least 48 hours in advance to avoid the victims driving up here unnecessarily.
Thank you, Your Honor.
And then you wanted to address, were you going to address bond?
There's a couple things on bond. There was a bond violation hearing set for this morning, Your Honor. I believe Mr. Bauer was out, had an issue with funding and paying for his tether, and that's why his bond got remanded set for hearing today. I think there's other
That's
issues.
incorrect, Your Honor. He let his tether die because he didn't charge it. That's why he got put back in.
Okay, I have one bond violation in this file. It's for shut off due to non-payment.
Oh, I apologize, Your Honor. I
don't have another one.
There's only been one, so I must have been correct. My apologies, Mr. Feigelson.
No, you're Ms. Feigelson, thank you.
Okay, and so it looks like he was arraigned for the bond violation. He represented to the magistrate that it was an honest mistake about the GPS tether, that he works all the time. I don't know how that has anything to do with work. He should be able to pay for the tether. I don't understand what the issue is. Bond was $100,000 cash surety with GPS tether, correct?
I think that's correct, Your Honor.
We'd be asking for the court to reconsider based on some new information that I'd like to provide to the court.
You can do so at this time.
Your Honor, the detective who's present in the court today and can speak directly on his firsthand knowledge if the court would like, the defendant has been contacting several people, I think most of whom are in the courtroom today actually, regarding making it quite difficult for the witnesses to appear for court. Specifically on December 8th, he made a call to a Rochelle Finch where they talked about payment, approximately $3,000 per month if she would agree, she meaning the mother of the children, not to come to court, asking them if she can talk to the kids about saying that nothing happened, like $3,000 a year for 5 to 10 years or something. I actually have the transcript in front of me of the call. That's the only call I've personally listened to. I did share that with Mr. Feigelson. Last night, the detective listened to several more calls. I think we're in the range of 8 to 10, possibly more, of calls to other family members who have accepted tasks like this from Mr. Bauer. And then I also just confirmed with the victim's mother that on Sunday, December 24th, they were reached out to via Facebook message asking for their new number. They've had to change their number, their residence, everything because of this. They actually don't even live in the state anymore. Asking for their new number because Mr. Bauer's mother would like to contact them. So I'm asking for a remand, Your Honor. And there will be additional charges for witness interference coming.
Did you want to respond?
Yes, Your Honor. I've not heard the calls from that Mr. Matusko heard before, but I did listen to the jail call on the 8th when I was leaving the court.
Okay, the allegations are that you have violated your bond conditions, which would be not to have contact directly or indirectly, and that this was communication happening through the jail call.
Correct, Your Honor.
Okay, so you would have the right, sir, to have a contested hearing as to any bond violations. And then as to what was stated by the prosecutor, it appears that based on these allegations, new charges may be issued for witness tampering. But we'll go ahead and note here in the file that we'll have a time set aside on our docket for a hearing for the alleged bond violations. You do have the right to be represented by Mr. Feigelson at that hearing. It'll be set for the same date as your next exam. In the interim, I'm going to go ahead and remove your phone privileges while you're in custody. In any hearing.
I'll draft and submit an order to that, Your Honor.
Okay, bond was already revoked. You will remain in custody until the time of the exam. Any
Thank you,
additional
Your Honor.
matters for the record?
Nothing from the people, thank you.
Nothing on behalf of Mr. Bauer, Your Honor. Thank you.
Thank you. We'll see you at your next court date, sir. Same to you, sir. Same to you. You're all set, Mr. Bauer. I don't know why Zoom does that. Okay, back on the record in the matter of the people of the state of Michigan versus Darion Summerhour, file number 23-02789FY, appearance.
Chief Petrowski on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Darion Summerhour, who is present and speaking to my right.
Okay, and so Ms. Donnelly, you did need additional time to talk to your client. Were you able to flesh out the issues or do you require more time?
Your Honor, no, I believe at this time we'll be able to proceed with the preliminary exam.
First witness, unless we have any preliminary matters.
There are no preliminary matters from people.
Thank you. You can have a seat, sir.
People call Officer Ryan Brooks, please.
Officer Ryan Brooks.
Oh, Officer Ryan Brooks. Mr. Nick would take them.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Okay, you can have a seat. You can state your first and last name and spell both.
First name is Ryan, the last name is Brooks, first name R-Y-A-N, last name B-R-O-O-K-S.
Please proceed, counsel.
Good morning, Officer Brooks. Where do you work?
Work for Lansing Police Department.
And what are your duties?
I am currently a patrol officer, which is, runs a beat of whatever district I'm assigned for that given day.
Were you working as a police officer on September 9th, 2023?
Yes,
And how were you dressed on that day?
I was dressed in full LPD uniform and driving a fully marked LPD.
When you were working on that day, were you dispatched to Meyer?
I was,
Is that the Meyer at 6250 South Pennsylvania?
that's correct.
And what were you dispatched for?
I was dispatched for a late assault report and a stolen vehicle.
And was there anything notable about this call?
Yes.
And what was it?
It is in reference to a call that we had earlier for a potential rolling domestic or someone driving on the road. We searched the area at that time, but we're unable to locate that vehicle. That was around 7:30 that day. And then obviously this call came in around 10:20, 10:30, where the victim did go back to the location of the Myers. Upon arrival at the Myers, I began speaking with the victim and her father. The victim stated she was assaulted by her ex-boyfriend while they were shopping there at Meyer.
Sorry, not to cut you off. What was the victim's name?
Elise Sharp.
And what was the victim's father's name?
I will be Sharp.
Okay. So, sorry to interrupt. If you want to continue.
So I took her statement in regards
Counsel?
to
I was preparing myself, Your Honor.
Okay. When you stand up, I thought you were
No,
gonna say
no,
objection.
but when he was talking, I.
Very good. Okay, you can proceed.
Going back to the two 911 calls, was a vehicle description given?
It is a black SUV.
Was that given in both calls?
Yes.
When you spoke with Ms. Sharp, how was her demeanor?
She was a little uneasy, kind of afraid, maybe a little bit in shock at the time.
When you spoke with Ms. Sharp, did you obtain any information about the relationship between her and Darian Summerall?
Yes, yes, I did.
My apologies. And what was their relationship?
They've been in a relation, or they had that was he is her ex-boyfriend. They've been together about 3 years, and they do have one child in common. I believe her name is Ashley.
And without telling me what she said, did Ms. Sharp describe or explain why 911 was called?
Yes. So initially, she said they got an argument.
All right, Your Honor, at that time, I'll just put my objection on the record for hearsay. Your Honor.
You want to respond to the objection?
Yes, Your Honor, I'm currently laying a foundation for further evidence to come in. So I reached out that I could continue laying foundation before I guess you make a determination on whether it's insane.
Before that, Your Honor, I'd want to know which statute she's bringing in.
Yeah, for the evidence coming under what?
It'd be coming in under MCL 768-27C.
Right. Okay, the objection is noted. We'll let her continue to lay the foundation.
So just to backtrack. So did she describe or explain why 911 was called?
Yes. So at the time, this is it spans over a kind of a time frame. She wasn't initially trying to call 911 at the time. And then when the vehicle was taken, her phone was left in the vehicle, so she was unable to call police at that time.
Okay.
So once she got a hold of her father, that's when I was actually notified to actually meet them at that location that morning to get her statement.
And did she, again, we'll get into the details later, but did she describe the infliction or threat of physical injury?
Yes, she did.
Did you learn when that assault occurred?
Yes, so that assault occurred earlier in the day when they were shopping at Meyer. It was going to be around 7:30 when that initial call.
And that was on September 9th,
Yes, that was on September.
And did she or anyone indicate whether the two 911 calls actually involved her and Mr. Summerall?
So, no, I mean, that was just kind of, the person who called was just a random bystander who saw it happen. And we looked in the area, but nothing, we never found anything. And we got this call and we obviously just kind of.
At this time, Your Honor, the people would seek to admit the statements from the victim, Elise Sharp, made to this officer pursuant to MCL 768-27C, as all 5 elements have been met. Particularly, the statements were made about the infliction of physical injury at or near the time of infliction, just later that day, involving the domestic relationship between the victim and the defendant here. And under circumstances that would indicate trustworthiness, she has no ongoing legal issues with the defendant in this instance, and they were substantiated by the corroboration between the two 911 calls in which she stated occurred, and they were made to a police officer, Officer Ryan Brooks.
Ms. Donnelly.
Your Honor, can I void the witness? Thank you, Your Honor. Officer Brooks, hello. So your testimony today was that there was a bystander that called in at about 7:30, you said, for domestic violence. So that bystander witnessed this assault, correct?
Allegedly, yes, as they were driving on the road.
Okay, and this bystander said that they saw, so they were driving down the road and they saw some in another car.
Is that a yes?
Yes.
Did this bystander's information get relayed to dispatch? Their name, contact information?
Not that I'm aware.
All right. And your testimony today was that officers were dispatched for that call, but no further information or victim or anything was found.
That is correct. We were unable to locate the vehicle that was mentioned.
Right. You also, it's your testimony that you were dispatched, you said about 10 or 10:30 to the South Penn Meyer.
That's correct.
All right. And And who, and you said it was that, at that time, it was the alleged victim that had made the call to dispatch, correct?
The person who called police at that time was Alan Sharp, the victim's father.
Okay. And when you arrived at the South Penn Meyer, was there anyone else with Mr. Sharp or the alleged victim?
Yes, I believe it was Mr. Sharp's son and Elisa's brother.
All right. And did they say why they were at the South Penn Meyer when they made the report?
Yes, they just went back to that location to get a report from police.
Okay. And did they say anything else that they had done in the intervening time between the assault and you being dispatched? Okay. Did in the complaining, the alleged victim, when you spoke to her, she said that she had a child in common with the suspect, correct?
That's correct.
Okay. And did she say that she lived with the defendant, Mr. Summerhour? So she said she didn't live with him.
No, she never said that she did or did not. She did mention. I
Okay.
did not ask.
All right, and you didn't, and did you ask about any current custody agreement?
No, I did not.
Okay. Did she state whether there was a current custody agreement?
No.
You mentioned that she reported that Darion was her ex-boyfriend, correct?
Correct.
All right, so so at the time, did she say, so at the time of the alleged assault, she was saying that they were not in a relationship together?
That's correct.
Okay. Did she say then why she was with Mr. Summerhour that day? And what did she say?
They were just shopping at Meyer for food and supplies for the child.
Okay. Your Honor, at this time, we don't have, there's further questioning, but we don't have the statements yet admitted. I would just be preserving my objection. We can listen to the statements and then I will have my final questions and my objection after that.
As to whether or not sufficient foundation has been laid for statements to come in under MCL 768.27C, I'm going to overrule the objection. You can proceed.
Thank you, Your Honor. So, and you had spoken with Ms. Sharp at the mic.
Yep. Yes.
Where did Ms. Sharp say that the incident first began?
The incident began in the parking lot of the Meyer when they were done shopping and trying to get back into the vehicle.
And is that Meyer located in Menacing?
It is.
In Young County?
Yes.
State of Michigan?
Yes.
So what happened, or what did Ms. Sharp say occurred when they had finished shopping?
So once they finished shopping, she stated that an argument ensued over who was going to pay for all the supplies or groceries that they got. While she was trying to put Aspen into the vehicle, Mr. Summerhour was being violent with her. She stated that he grabbed her hair while she was in the back, trying to put Aspen into the car seat. He was in the driver's seat. He reached back, grabbed her hair, and started yanking it around, yanking her head around and pushing up against the sofa. They continued to argue. She stated that it became so violent that she actually got pulled into the vehicle, and that's when it became the assault started from the vehicle and then turned into the rolling domestic while he was driving her.
And when she said that she was pulled into the vehicle, where into the vehicle was she pulled?
In the back seat or the center seat.
And where was Mr. Summerhour at the time?
He was driving the vehicle or in the driver's seat.
Did Ms. Sharp indicate whose car it was?
When I went to the interview them both at the Meyer, yes, it was her father's vehicle.
And did she have permission to drive the car? Did she indicate whether defendant had permission to drive the car?
She did not.
Didn't indicate or didn't have permission?
Your Honor, I'm going to object. These are not hearsay statements that are narrating an infliction or threat of evidence, so there needs to be another exception to get them in.
Your question was, did she say whether or not he had permission to drive?
Whether she knew if defendant had permission. And I would argue that it's admissible under two theories. One, I would argue that it still is on narrating or explaining the circumstances of an ongoing domestic assault, which is what the statute, which is precisely covered by the statute. And additionally, these statements are being given at a preliminary examination to show possession, use, or ownership, which is covered by the MRE 1101 subsection B subsection 8 rule that would allow those statements to come in.
Okay. As to your first response, I tend to agree with that. He's giving a narration of an incident involving domestic violence. And this is essentially one continuous action. The indication so far is that this was an assault that took place at or near a vehicle and that she was pulled inside of this same vehicle. So I believe that the hearsay objection is overruled. You can proceed. You can give the response. Again, if you remember the question.
So from there, she was essentially forced into the vehicle, and then Mr. Samawa began driving that vehicle. Police stated that she at times didn't know where she was in the city, that he just was driving around erratically and didn't know where he was or where he was actually going. Eventually that led to her being dropped off at one of her friend's houses. I'm not entirely sure where that was. She did not mention it. But at that time, she also stated that an additional assault did occur where when she had Aspen in her arms, Mr. Samawa would continue to punch her with a close fist in the head and stuff.
And did that second part of the assault, did that occur while Mr. Samara was driving?
No, so as it stands from her statement, he dropped her off at her friend's house. They both were out of the vehicle at that time. So that assault occurred there, and then Mr. Samawa drove off with the black Chevy Traverse. I believe her purse and phone were still in the vehicle.
Did Ms. Sharp ever indicate that she gave the defendant permission, or excuse me, gave Mr. Summer permission to use the car?
No, she.
And he assaulted her the second instance.
Mm-hmm.
Could you describe what the actual assault consisted of?
Yes. So got out of the vehicle and grabbed Aspen, and she was carrying Aspen. She stated that Mr. Summerhour then got out of the vehicle, went up to her, and they were still verbally arguing at one another. He would continue to punch her. I believe he said twice in the head and then twice in the stomach while she was holding her baby.
When you spoke with Ms. Sharp, did she provide you with any identifying information about Mr. Summerhour?
She did.
What information did she provide you with?
She just said it was she provided his name and date of birth. He was a black male. Last seen, he was wearing a black jacket and black.
She provided his phone number?
She did not.
Did you enter the information, did you enter his full name and date of birth into either LEAN or the SOS information system?
Yes, I entered his name and date of birth into the.
And did you find any results?
Yes, I found his SOS, so his driver's license images, his basic information.
Okay. And you say driver's license images, so were you able to view the picture?
Yes.
Okay. And would you recognize that person if you saw them here today?
Yes.
Okay. Is he present in the courtroom?
Yes.
Can you describe an article of clothing in the location?
He's wearing a white suit.
Let the record reflect that Officer Brooks has identified the defendant.
Any objection to identification?
No, Your Honor.
Identification is noted for the purposes of the preliminary examination.
Was there any sort of tracking device or GPS device in the car?
Yeah, so when I took the report at the Meyer parking lot, I was speaking with Mr. Sharp, the owner of the actual vehicle. He told me he had an eye tracker device in the vehicle, so he was able to get pretty up to date ping locations of where the vehicle was.
And was that information of where the vehicle was that relayed to you? Was the GPS location, like the information coming from the GPS tracker, was that information relayed to you?
Relayed to me, yes, it was.
Sorry, I'm asking. Do you remember where the car was last located or last seen with the GPS tracker?
Yes, I believe it was near Profit and Moffett Street, or Prospect on Moffett Street, where we found the vehicle. That's where the last thing was given to me.
And can you describe the vehicle?
Yes, the vehicle is a newer Chevrolet Traverse in black in color.
Was it occupied when you found it?
It was not.
Were there keys there?
No, there was no keys that I could visually see. However, it's a push to start model. So I tried to activate the vehicle and it definitely wanted to, but it indicated that there was no gas.
So the gas tank was empty?
Right.
Did you check the registration information on that vehicle?
I did.
And who was that vehicle registered?
Going to Albert Sharp.
Was that consistent with what Ms. Sharp had told you?
Yes.
No further questions. Cross-examination.
Again, Officer Brooks, so it's your testimony today that the alleged victim had told you that Mr. Summerhour had punched her with a closed fist multiple times, correct?
Correct.
All right, and did you observe when speaking to her any injuries?
No injuries were visible.
Did she say where she was punched?
She told me she was punched in the head and stuff.
All right, and this occurred while she was in the back seat of a moving vehicle and also outside of a friend's house?
That's correct.
Okay. Did she specify where the separate assaults happened or what he did at different places?
Not necessarily. She seemed pretty disoriented when she was in the vehicle, and she told me that she didn't know where she was at most of the times while he was driving.
Okay, so did she know whether she was still in the city of Lansing? But she said she got punched in the head and the stomach, correct? And you didn't observe any redness or swelling or anything on those areas?
Nothing, no redness or swelling on her face or skin, anything like that, just she will care. Her hair was.
Okay. And she did not seek any medical attention, correct?
She did not seek medical attention.
All right. No further questions, Your Honor.
Please redirect.
No, Your Honor, thank you.
May the witness be excused?
Yes, Your Honor.
Thank you, Officer Brooks. You may be excused.
Thank you, Your Honor.
Any other witnesses today?
No, Your Honor.
Okay, is defense calling witnesses?
Your Honor, I have no further witnesses. I have no witnesses.
Okay, you can proceed to argument.
Thank you, Your Honor. Officer Brooks's testimony today established that to a probable cause standard that the venue of this incident was in fact in Lansing, in Union County and in the state of Michigan, and that it occurred on September 9th, 2023. Officer Brooks was able to identify the defendant using the corroborating evidence, excuse me, given to him by the domestic violence victim in this case, Melissa Sharp. The elements of the unlawful driving away were established by his testimony as well, and that the vehicle was registered to Mr. Alvin Sharp, and also Mr. Sharp and Ms. Sharp both indicated that he was the person who had ownership of the vehicle. The defendant took possession of the vehicle and drove it away by getting into the front seat and by driving the vehicle when he was not given permission by the victim in this instance. The victim, Ms. Sharp, had permission to use the vehicle from her father, the lawful owner, but she herself did not give permission. And given that she was shoved into the back seat in order for defendant to take her driving in areas that she didn't even know where she was, it's pretty clear that he was not doing that with her consent or her through authority given by her. And although obviously Officer Brooks can't speak directly to the state of mind of the defendant in this case, it's very clear based off of his actions that he intended to take it without authority. Otherwise, he could have maybe not assaulted the victim. He could have done other things to have either sought permission to use this vehicle, but not assault her, drag her into the back seat, drive her around for an unknown amount of time in unknown locations, and then drop her off and leave her at her friend's house with a child and then continue to assault her. Those aren't the actions of something that someone is doing if they believe that they have the authority to do what they have the authority to take control of that vehicle. So to a probable cause standard, the elements of unlawful driving away have been met, and the people asked the court to bind over to the circuit court as charged.
Thank you, Your Honor. For the record, I would just like to preserve my objection to the 27C evidence. I know that Your Honor had already admitted it, but I also wanted to put on the record that it is the defense's position that the statements given do not arise to be admitted under 27C. These were under circumstances that would indicate or that it made at or near time the infliction or threat of the violence. In this case, we have what seems like a 2 to 2.5 hour window between the time of the alleged assaults and the time of when police were dispatched. Now, it could be that cases have found that it could, days later, it can still be at or near the time, or hours later, it could not, it's not close enough. It depends upon, again, when the officer was testifying to what he perceived as Mrs. Sharp's mental state, admitting that, he obviously can't read minds and he doesn't exactly know, but what he testified to was that she was uneasy, afraid, and she might be in shock. Your Honor, again, this is 2 to 2.5 hours after the fact. She has her, now she is back at the Meyer location with her father and other family members. There is plenty of time for, that leaves plenty of time for what she's going to say to the officer to be developed and formulated. And so there is that. And then also trustworthiness. There is another 911 dispatch call, but the officer testified that they never got that person's information, so we can't ask them about it. Obviously, the two people who are the alleged victims of this case are not here to corroborate. We also have the officer testifying that the alleged victim was allegedly punched multiple times over in a car, traversing the city, also in front of a friend's house where we don't have the address. Again, we have to establish that this all happened in the city of Lansing, and there's questions as to that too. So, with that, Your Honor, we just, like you said, preserving our objection to the 27C evidence. Thank you.
Thank you. Okay. Today was a date set for preliminary examination. The burden is squarely upon the prosecution to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you, Mr. Summerar, with count 1, motor vehicle unlawful driving away. Count 2 is a misdemeanor, so they do not need to meet the burden of probable cause for that purpose. Nonetheless, this matter, as indicated by the prosecutor, is one continuous action. And so they proceeded under MCL 768.27C to admit hearsay testimony. And 27C allows the admission of hearsay testimony from a declarant if all of the following applies. The statement purports to narrate, describe, or explain the infliction or threat of physical injury upon the declarant. The declarant in this matter being the alleged victim, Melissa Sharp, and that the action in which the evidence is offered under the section is an offense involving domestic violence. So that means it just needs to be circumstances or narrating an incident involving. It does not just need to be domestic violence, but it has to involve domestic violence. The testimony given today was that the officer reported to the Meyer in Lansing. I don't know that he said the address, but the court's very much aware of 6200 South Pennsylvania Avenue. Is that supposed to be the address if this occurred?
It was, and at least I believe he did confirm that that was the address.
Okay, I think the address that I have on my complaint's a little bit different, so 6250, but it should be 6200. We'll make sure that that's properly addressed. Nonetheless, he did indicate that this was the Meyer in South Lansing, in the city of Lansing, Ingham County, that he made a contact with the alleged victim, Alyssa Sharp, that he described her demeanor to be afraid, uneasy, and he said maybe even a little in shock, that she gave testimony about an incident involving her ex-boyfriend, that they had been together for 3 years, one child in common, believed the baby's name to be Aspen. And that the victim called 911, that a vehicle was taken from her, and that her cell phone was inside of the vehicle, which prevented her ability to make a contact with the officers earlier on. That's important because that goes to the argument that your attorney is making about the proximity of the complaint or the narration to the officer. So another element of 27C would be that the statement was made at or near the time of the infliction or threat of physical injury. Evidence of the statement made more than 5 years before the filing of the current action or proceeding is inadmissible under this section. This is an incident where allegedly the time lapse was maybe 2.5, 3 hours before there was contact between Miss Alyssa Sharp and the officers. The court does believe that to be within the standard of close proximity, especially considering the circumstances narrated, which is that the vehicle was taken without her permission and that her phone was inside of the vehicle. And so that put her in a position allegedly to be unable to make contact with law enforcement until she was able to get in contact with her father and back, I believe, at the location of the original incident. The other element that must be met under 27C is the statement was made under circumstances that would indicate the statement's trustworthiness. The statement must also have been made to law enforcement officers. So this is a statement that was clearly made to Officer Ryan Brooks, who's an officer of the Lansing Police Department. He stated at the date of the incident, he was on patrol as a patrol officer in full LPD uniform and dispatched in response to the report of the alleged domestic incident. As to trustworthiness, the court considers factors of the demeanor of the alleged victim or witness. And again, he testified that she appeared to him to be afraid and uneasy. He did testify that she had some disheveling to her hair. He did not note any redness or swelling, but that the statements also could be corroborated by the fact that there was a dispatch made also around the time of the alleged incident from a bystander who called in to make a report that they saw an assault in that area and location as they were driving down the road. Does not matter that they didn't provide their name or contact information. That's just additional information to corroborate the fact that there was another bystander that saw an alleged incident occurring at around that time in the location alleged in this particular incident. The court has no reason to believe that the officer's statement today of hearsay lacked any trustworthiness for the purposes of today's preliminary examination. Count one, again, motor vehicle unlawful driving away. The testimony of the officer was that the victim, Ms. Sharp, indicated that they were picking up items at the Meijer, or at which point there was an argument that ensued about who would pay, that the defendant or the person that the officer stated he identified in court as the defendant grabbed Ms. Sharp by the hair, that the altercation became more violent, that the victim testified or told the officer, I should say, that she got pulled into the vehicle from the back by her hair, and that the defendant was located in the driver's seat, that the defendant drove around erratically, and at one point, Ms. Sharp was unaware as to whether or not she was even still in the city of Lansing. However, the incident initiating in the city of Lansing for us as to count one is sufficient. At count two, again, we don't need to address probable cause, but if we were going to address that, there was a testimony about an assault that occurred at the Meijer parking lot. And so the testimony involving the additional allegations of assault while in the vehicle have not necessarily been charged. We don't need to establish where in the city or state of Michigan that could have allegedly have occurred. The court is satisfied that there is sufficient probable cause as to count one and to bind over to the circuit court. Your bind over date is going to be January 10th. You do not need to appear in court on January 10th. That's the date that the circuit court gets the file from the district court. Count two will accompany count one. Your attorney will be made aware of your next court date. It's going to be a pretrial in circuit court, and it'll be set after that January 10th date, okay? Your bond was set at 20,000, 10%. I think I amended that, 10,000, 10% with GPS tether and victim notification. Any reason why we need to address bond today?
Only that, Your Honor, in regards to the tether, Mr. Summerhour has been on it since September, without any issues. You all have to pay for it, correct? Okay, so if there would be no objection, I would ask that the court consider removing the tether for now, so he's not incurring any further costs.
People would be objecting to removal of the tether. I believe there was a failure to appear on this case. And given the nature of the violence done upon the victim, I think that it's most appropriate to keep the tether in place. Otherwise, bond is appropriate as is.
I don't see a failure to appear. However, that on this file. However, the purpose of the GPS tether is to ensure the safety of the victim in compliance with the court order. The court doesn't really need to consider his ability or willingness or concern about paying for the GPS tether. And the fact that he's been compliant is exactly what the purpose of the bond is for. So we appreciate that you've been compliant. I don't see any reason why we need to change that because you've been compliant. You need to continue to be compliant. And that's no contact directly or indirectly with the alleged victim, Alyssa Sharp. You're not to be within, it says 2,000 feet of wherever she is, and you need to have GPS tether. Do you have any questions about that? Okay, bond will continue as said. Any additional matters for the record?
Just briefly, Your Honor, I wanted to apologize. I misspoke. I had this case mixed up with a different one where there was failure to appear, so I don't want to state that.
No, I was gonna say he appeared every time in my file, so
yeah,
I know that there was something about a global resolution, so I don't know about another file, but
no, my apologies.
Okay,
But,
sounds
and nothing for people.
thank you. You're all set.